All right, so good afternoon, everyone. My name is Sarah Rubidoux Lawson. I'm an enrolled citizen of the Iowa Tribe of Kansas and Nebraska and an attorney at Schwab Williamson & Wyatt in Seattle, Washington. I am also a member of the National Tribal Land Association Board and have been involved in the organization pretty much since it started. I'd like to welcome you all to our conference this afternoon. A few announcements. So this is a CLE track course. If you're like me and you get a notice from the state bar every year claiming that you're an attorney and making you do continuing legal education credits, you'll want to make sure that you sign in at the sign-in sheet up here at the front so that you do, in fact, get those credits that you can report back. And then for everyone in the room, there's going to be a quick survey that is handed out. It's going to be on a little blue card. We'd love to get your thoughts back on the presentation and what you liked and perhaps what you didn't like. And you can just return those back up to the front of the room here, and NTLA will collect them. And with that, it's my pleasure to introduce Michelle Lee from Circle Law Group.
Okay, hi everybody. I'm Michelle, and I am a member of the Pit River Tribe from northeastern California. I am an attorney, and I've been practicing in the Indian law field since 1999. And my practice is in Sacramento. A big part of my practice is land back, basically. Today we call it land back. Used to be just taking land into trust, fee to trust. But over time, the structures of taking lands and getting lands transferred has really changed. And when I came out of law school in 1999, I remember having conversations with people in the Indian law field, and they would say, well, we have a tribal federal relationship. And so we have a relationship with the federal government. They have a trust responsibility to us. We don't really want to be interacting with the state. And me being in Sacramento, knowing all of the hurdles that we faced with particularly, it started with compacts, actually, because our tribal state compacts, the state wanted tribes to mitigate off-reservation impacts from casinos. And I just really, as a Native person, being a member of the Pit River Tribe, I really thought that was terrible that the state would require tribes to negotiate for off-reservation impacts of their casino projects on their trust lands when off-reservation, no one ever talked to us about what they were building. And no one consulted with us on projects outside of Indian country, unless it was through, what we call Section 106 of the NHPA, National Historic Preservation Act. And that was only on federal projects. So the reason why I'm talking about this is when I started in 1999 in my practice, we really didn't have any kind of consultation. There was no consultation rules. There was no interaction with these state agencies. And tribes were in this bucket of dealing with the federal government until we started this compacting for gaming. And then there was this blossoming of interaction between tribes and the state. And again, going back to the off-reservation mitigation, I thought, well, why aren't these agencies talking to us when they're making decisions that affect our ancestral lands and our tribal cultural resources, our natural resources, and they're not serving us. They're not serving our community at all. We're paying taxes sometimes where we shouldn't. As tribal people, tribal communities, paying taxes on utilities. For utilities to be in our country, in our homelands, and regulating our natural resources and taxing us for the services that they're providing to the tribe. And it just really dawned on me that there was work to be done. And so being in Sacramento, I was lucky that I was able to have access to folks in Sacramento. And this sort of began my journey. And what I'm going to talk about today, my other panelists didn't make it, so I get to hold you all hostage today and tell you about my journey, figuring out how this problem that I'm talking about, for where utilities are taking from Indian country, how we can get some back. And it's been a long process, and I'm going to take you through it. The topics that I want to cover are specific to my tribe, And I'm just kind of having this be sort of a case study, but it also is, the reason it is my tribe as the case study is because the Pit River tribe did get almost 2,000 acres of land back from PG&E, Pacific Gas and Electric. And it took a very long time to do that. And as a result of this process and interacting with agencies, we now have some policies and some real guidelines for other tribes to get land back from utilities. And if there are some of you that are not from California in here, I would just like you to consider if your state, if you have these kinds of opportunities in your state that your tribal lands are in, and if not, maybe that's something that could be pursued, because the resources that the utilities have, as I'm sure we all know in here, are really important to Native people, and they do belong in Native hands. So we're going to talk about the tribe. We're going to talk about the creation of what was called the Stewardship Council, the Pacific Forest and Watershed Lands Stewardship Council. I'll try to make it not boring, because I think it can get boring if we get too deep into it. Talk about what it means to have lands donated, and they call it donated, from PG&E. And I'm going to specifically show some pictures and some maps to kind of lighten it and show exactly where we're going with this and how PG&E has given some of the land back, but not all of it, and definitely not like the best land. They've held out the best for last, and so we still have more work to do. And then I'm going to talk about what happened after that, that there was some changes in the state's consultation policy, really high level. I'm not going to get too deep into it. And then talk about the CPUC tribal land return policy. And I am going to break that down a little bit so that, you know, if anyone here is from California, that you have an understanding of it. And if you're not, that these are some things that maybe you could look at in your own state. So I am really proud to be here today representing this Pit River tribe. I see another tribal member in here, so I'm super excited. There's other tribal people here. But the background of the tribe, our tribe has 11 autonomous bands. It's a really unique structure, particularly in California. And for those of you that maybe are new to Southern California, you have all these tribes, right? You have Pechanga and Pala and Rincon that are Luiseño tribes. They have lands scattered down the road here. But they're interrelated tribes, but they're separate tribes. They all have their separate jurisdiction. In our tribe, we have 11 autonomous bands, similar to the 11 small tribes, but we're all under one tribal government. And we have a very large territory that we call the 100-mile square. And it covers 4 counties in the state of California. So we have Shasta, Siskiyou, Modoc, and Lassen counties. So it's a very large Aboriginal territory. And if you look at a land map, a topographic map of the state, that area is very mountainous, it's high country, and there's a lot of natural resources. And because there's so much natural resources there, non-Indians wanted it. And so a little bit about the tribe and our history. In 1848, California was actually part of Mexico. And there was a Treaty of Guadalupe Hidalgo where the United States and Mexico entered into a treaty. And the lands of California were ceded from Mexico to the United States. And so we have a history of this Treaty of Guadalupe Hidalgo where the state of California said they would recognize Indian title. And of course they failed to do that. And if any of you were at the noon talk, Professor Miller talked about how the states make promises at the beginning, but then they, don't follow through with them, and that certainly happened here. There were not that many people besides native people in California at the time of the Treaty of Guadalupe Hidalgo. Non-Indians, there was, up north, there was fur trappers and explorers, and there weren't too many people that wandered into our territory because Pit River people are very fierce warriors and really tried to keep non-Indians out. A lot of immigrants, thousands and thousands of immigrants attempted to cross over the Lassen Trail through the heart of our country, but the tribal people raided those caravans, and they really defended our territory and tried to keep people out. And they really did a good job of defending and keeping settlement out for quite some time. In 1850, the tribe really never wanted to acknowledge the loss of land. They didn't want to give in. We never ceded our territory. We never signed a treaty. And other tribes in California, they did sign treaties, but they were later not ratified. They were never ratified, so we don't have ratified treaties here in California, unlike in Oklahoma. But the Pit River tribe never signed a treaty. But in 1851, there began the process of a land claims commission, and that, I'm not going to get too in depth on it, but that land claims commission was the process whereby the tribe lost its aboriginal claim of title to the lands in our territory. So the tribe ended up with pieces of land, little parts of land across our 100-acre square or 100-mile square. But it wasn't until 1987 that the tribe adopted a new tribal constitution, and the Secretary of Interior approved that constitution and designated the tribe as a beneficial title holder of what we call XL Ranch, which is up in Alturas. It's about 8,000 acres. And prior to this, there had been a 20-plus year legal battle over the structure of the government and how it was going to be organized. And the approval of the Constitution really culminated all of those years of difficulty and created a tribal government. There were 5 rancherias that were Lookout and Likely, Montgomery Creek, different rancherias, which today we still have rancherias in Northern California, but they're all separate tribal nations. In Pit River, the rancherias within the 100-mile square all were folded under the jurisdiction of the Pit River tribe as a government. And our tribal center is in Bernie, California. And as I said, our land base is scattered across 4 acres. And I wanted to set that table because we have a very small land base, but most of the land that was taken, the tribe created a conflict with PG&E in the early 70s. And the conflict with PG&E was based on that history that I mentioned about the Land Claims Commission. And the Land Claims Commission had essentially wiped out the tribe's aboriginal title, saying that the tribal people, didn't participate, that we didn't make claims, because of course we didn't know we were supposed to. No one had told us that we needed to make a claim to our own land in this commission. And the title was lost. And when that happened, enterprises like PG&E acquired our land, and they acquired all of the watershed lands. So they acquired the lands that are precious in natural resources and used for utilities. So there's many water projects, hydro projects on the waters, Fall River, and the Hat Creek, and the Pit River, of course. And so we have PG&E, came in and they developed the utilities in our Aboriginal area and excluded Indian people from many of these watersheds. And later in time, I want to say starting in the 1970s, PG&E, because of FERC proceedings, did start consulting with the tribal people and the different bands that had Aboriginal territory in PG&E holdings. They started negotiating and consulting with PG&E about access to our original lands in the water and resources. There's burials, there's basket materials. And So the tribe started this dialogue with PG&E. It was very hostile early on, and PG&E really wanted to exclude Indian people from any role in PG&E. But then in 2003, around 2000 actually, 2000, 2001, I was on the tribal council of the Pitt River Tribe. And I received a notice on behalf of my band, and I'm Hamawi Band of Pitt River Tribe, and I received a notice saying that PG&E was going into bankruptcy and they were going to sell off the lands that were in our territory basically to the highest bidder. They were going to have an auction, essentially, and it was open to offers. And when that happened, I thought, well, you know, my tribe, this is our land, we should be able to get it. We should be able to have a first chance to buy it. And I was very anxious about this because at the time, you know, this was in 2000, 2001, my tribal council was included a lot of tribal elders who had been through all of that history, right? They had been through the history of knowing the land claims had taken our rights to our Aboriginal title, that we had been left out of our discussions about our lands in PG&E territory, and that we had been excluded. And so when I came to the table and said, you know, that we could buy our land, they thought, I mean, I probably was offending them so deeply at the time, but I was a young person, I was just out of law school, but they said, there is no way we will buy our own land back. It's our land, we should not have to pay for it. And I understood that, and I respected it, that they didn't want to buy their own land back. But there was this brief window where that opportunity was presented to us. And in hindsight, you know, I don't know if that would have actually led to closing, because what happened was there was a lawsuit because PG&E was going to sell off all of their lands. The lands are so rich in, you know, fishery and biology and plants and resources, and of course the water. And so there were many parties that got wind of PG&E's bankruptcy. Just like me, they were on the distribution list for all of the notices, and they had read about the fact that PG&E was going to sell off all of these watershed lands. And it wasn't just in my area, it was in many other areas, and I have a slide coming up that shows that. But they were going to sell them all to the highest bidder. And so other organizations like Cal Trout, Fish and Game, environmental organizations like the Sierra Club, anyone that was looking and had an interest in the resources that we were talking about with these highly sensitive beneficial values, they all stepped up and they joined in the litigation that was pending, the bankruptcy, and they intervened. And they intervened, the tribe, we did not intervene formally, really because of a lack of resources at the time. But I was able to just be an interested party on my own. And so I was able to participate in that proceeding and observe when that started happening, where there was dispute about whether PG&E could sell the land. And as a result of all of these parties stepping in, there was a settlement, and a settlement was negotiated where as a result of the settlement, PG&E was going to create an entity called the Stewardship Council, the Pacific Forest and Watershed Lands Stewardship Council. We just call it the Stewardship Council because that's a really long title. So the Stewardship Council was created as a result of settling this dispute over whether PG&E could sell their land. And they created a board of directors. So this was in December of 2003. There was appointments from different state, federal agencies, water districts. They had Native American and rural interests represented, but they weren't tribal representatives. They were, interestingly, the person that was one of the tribal interests representatives, her name was Darcy Houck. And Darcy, I was hoping maybe she could come today, because, but I wasn't able to get her here. but she's now a commissioner on the California Public Utilities Commission. But she, at the time, was working at the California Energy Commission. And the reason why I'm mentioning her specifically is because we have to have allies at the table for our voices to be heard. And luckily, Darcy was in a position, and I probably should call her Commissioner Houck, but she's a good friend of mine. We go way back. Went to law school and we went to undergrad together. She is also a Native person. Her ancestry is Mohawk from New York. And she had represented tribes along the way. She'd been an Indian law attorney. But she was uniquely qualified to step in because she was, at the time, general counsel for the California Energy Commission. And she was a Native person. And so she was there as kind of the representative of Native American and rural interests. And then we also had a representative from a state entity called the Native American Heritage Commission. And the NAHC has its own function with protecting burial sites and cultural sites. But Larry Myers was the executive secretary at the time. And so Larry Myers and Darcy Houck were our Native American interests representatives on the Stewardship Council. And it was key that we had those representatives and those voices because Larry's a Pomo I believe, from Pinoleville. And having Larry and Darcy as part of the Stewardship Council allowed them to kind of have to deal with the frustration of educating people that really don't want Indians at the table. They really did not want tribal people at the table. This was all the environmental organizations, and they thought they know what's best for the land. And having tribal people, in their view, really complicated it because we are sovereign, right? Tribes are sovereign, and some of the tribes have casinos. And that worried them. They thought, well, if we let native tribes become a part of this, then maybe they're going to want to take that land and put it into trust and have a casino on it, which is obviously not what we were trying to do. But that's a stereotype out there with these agencies. They think these things that they're afraid of. But so the Stewardship Council, they developed a plan, and I have it in quotes, protect, because that's a word that's up for debate, right? Who best to protect our Aboriginal lands than the Native people? But they really think they know better, right? They know what's best for the protection of what ended up being 140,000 acres of watershed lands that are currently owned or then owned by PG&E. And the watershed lands were going to be protected through this Stewardship Council process that would establish a process where PG&E would find a donee, an interested donee, and they're called the donee, and this is a legal piece, but when you have a transfer of fee title from one party to another and there's not a payment made, that's called a donative transfer. And so it's a donative transfer from the grantor to the grantee, and so it became just part of this process that whoever was going to get the fee interest in these lands was the donee. So there's a donee that gets the fee interest, and then there would be a conservation easement that was required to be overlaid over that fee interest. And of course, the tribes, we didn't like that. We didn't want to have a conservation easement by a third party overlying our fee lands, for obvious reasons. We want Aboriginal title back, we want the fee interest back, and we want to be able to govern it and put it into trust and hold it for the best interest of the tribe in perpetuity. But unfortunately, because the way this process was set up, where you had to have a conservation easement on it, some of the folks from BIA know you can't take land into trust with a conservation easement on it. So by its very nature, this transfer, the donative transfer, unless something changes down the line, which I hope will happen and we'll try to work toward, the lands that were transferred in this initial land transfer process can't be taken into trust, but they also are not taxed. So we do get the benefit of an endowment from PG&E that will pay the taxes in perpetuity. So the 140,000 acres are located in really mainly the mountains. They're up in watersheds. They're in Tuolumne County has some watershed areas. There's some in El Dorado County where potentially Shingle Springs would have, the Shingle Springs Band of Miwok Indians would have rights. So they're in, and Butte County, where some of the Butte County tribes are. And I'm not sure about on the coast, but the Stewardship Council lands were primarily in sort of the central and the Sierras. They're diverse. They're located in 21 counties from the northernmost where Pitt River's acquisitions were all the way down to the end of the Central Valley, down near Lemoore. There's some properties there. So as a result of these parties getting involved, the Fish and Game and all of these NGOs and other governmental agencies, it also included the UC system. So the UC, they have different study camps and things in some of these areas. There's all of these interests vying for the land. And what the Stewardship Council did is they prepared what's called a land conservation plan. And in their land conservation plan, they required all of the people or all of the entities that wanted to get the fee title, we all had to prepare a land conservation plan. And they're very thick documents, very comprehensive, very complicated documents focused on conservation and focused on identifying what are the beneficial values of the land and how would the donee, here we're talking about Pitt River, how would the Pitt River tribe manage those beneficial public values? The other downside to this process was that it had to remain with public access. And obviously that's in conflict with tribal sovereignty, where when lands are under tribal jurisdiction, you can have the power to exclude. But on these transactions, at this point in time, the Pitt River tribe does not have power to exclude from the lands, and obviously there's a conservation easement, so others are also monitoring it. But at some point, we do hope to make a change to that. So there was a phased approach. And I highlighted the dates in here because otherwise it's just a lot of words. But the reason why I wanted to highlight the dates is because this took a really long time. It started in 2003. In 2010, the Stewardship Council finally, after lots and lots of work by Larry Myers and Darcy Houck within the Stewardship Council, advocating for us, and myself on the outside, I didn't represent my tribe for just a chain of events, but I represented another tribe, the Potter Valley tribe, and we also were going through this process. So I represented Potter Valley, and it took a long time. In 2010, the Stewardship Council proposed donating lands in the Hat Creek and Lake Britton project to the tribe, but it wasn't until February 22 that it was finally approved. And that's a huge burden, right? The tribe had to carry this. They had to go through this really complicated process, and it took 12 years. But in order to do it, we had to walk through this list. We had to show whether it was either tribe. And there was another tribal group, the Maidu Land Stewardship Council, or something along those lines. And they also were an intertribal organization that went through this process and obtained land in 2022. But we had to meet all of these criteria. We had to preserve and enhance habitat, preserve open space, create recreational facilities to allow for recreation, because obviously these are rivers and waters that people canoe, they do all kinds of, they do fishing. Cow trout was a big voice in this whole negotiation. And there had to be sustainable forestry practices to enhance the habitat. And of course, these lands were terribly managed by PG&E. And when I was working with Potter Valley and we went out to the land, because Potter Valley received around 1,000 acres from PG&E in the land donation process, and when we went there, it was very scary because there was so much dead wood. And at the time, we started really having a lot of major wildfires. And so we actually thought twice about doing it, about moving forward with the acquisition, because there was going to be a lot of work that needed to be done to restore the forest to where it needed to be and be healthy. It was going to require a lot of controlled burning, a lot of removal of old wood, but we also had to balance the fact that it's an old growth forest, so there's habitat, and it gets very complicated from a land management perspective, which it costs money. And we also had an obligation, which of course we had no problem committing to, which was the protection of tribal cultural resources. So this again just shows the timeline. There were 2 proposals. There were these different planning units, and I don't want to bog down too much in the details of them because I'm not going to give you a test at the end to see which one's which. But there was Hat Creek and there was Lake Britton. Hat Creek and Lake Britton are in the ancestral territory of the Ilmawi band. And so because there might be another band that has ties to at least one of them. But in our tribe, each band has the right to have its say with regard to tribal cultural resources and land within that band's territory. So each band had a heightened role, and I was hoping one of the representatives from the band could be here today, but unfortunately he couldn't be here. But ultimately, the tribe wanted to have a land return from both of these projects, and there was actually another one. And as some of you might know, when tribal people want these kinds of transactions, we have competition, and we had competition from a non-Indian organization that got kind of disrespectful and racist in the process of this transaction. And that was very challenging to not respond to, ignorance and the lack of education on the part of this other group. But for 2 of the parcels, we got it to completion. So it's approximately 1,700 acres. I think it might be a little bit more than that, but I was running my numbers and it might be a little bit more. So once we negotiated with the Stewardship Council, it had to go through a long process of approval with the California Public Utilities Commission. And that was really the basis for some of this next part. So this is phase 1, right? Phase 1 is the tribes struggling their way through this process, through this bureaucracy, educating everybody at the CPUC and the CEC and all of these state agencies and getting them to understand tribal issues. And then what happens after you get them there? And that's kind of the next part. These are just some maps to show what we're dealing with, and I can't say exactly which parcels went to the tribe, but the blocks that are kind of green are blocks that are parcels that were made available. The purple are what the PG&E calls retained lands, and so they're not willing to give up anything that's in the FERC boundary, and the FERC boundary is the Federal Energy Regulatory Commission. And that's because there's hydro facilities and because they generate power and they're owned by an independently owned utility. They're regulated by the FERC license, and nothing within the FERC boundary was made available yet. And I say yet because I really hope that at some point in time we can complete this and make it whole. So you can also see that some of the parcels as a tribe, we might not want, right? I don't know about the pointer up here, but there's some parcels in that left side to the right that are isolated, and there's some parcels that are just landlocked. And PG&E and other utilities, the thing that I learned during the course of this process is that they own a lot of land and they own a lot of other kinds of facilities. They own buildings and offices and different structures that could be made available to tribal people across the state, not just in these watershed areas, but in other areas, even in San Francisco, downtown San Francisco. But this was the scope of what the Stewardship Council was looking at. And again, it took 12 years of lots of meetings and lots of work. One of the real hurdles was sovereign immunity. And again, since there's CLE credit, tribal sovereign immunity is the inherent authority of the tribe to be protected from lawsuits by third parties for any purpose. And the only time that a tribal government can be sued is if there's a waiver of that sovereign immunity. So in the course of doing these transaction documents with the Stewardship Council, they insisted that there be a waiver of sovereign immunity. And as an attorney, it's expected. But it's not always something that a tribe likes or wants to do, because we can often feel like it's a violation of tribal sovereignty. But the reason why a waiver would be needed in this really complex transaction is that if the Pitt River tribe was grant deeded all of this property and made commitments that they were going to respect the conservation easement and we were going to do certain things, and there wasn't a waiver of sovereign immunity, the tribe could just say, well, sue us. You know, we're not going to do it. And if they did sue us to try to enforce those promises that we made, we could say, sorry, we didn't waive immunity, the court doesn't have jurisdiction, and they wouldn't be able to do anything about that. And so PG&E was keenly aware of that a tribal sovereign immunity waiver was needed. It was a limited waiver, and the difference between a limited waiver and a general waiver is that a limited waiver is only a waiver for that transaction. So what I always like to say is the four corners of your document. And if any of the promises in your document, if there's a limited waiver, then that means that other party that you're contracting with can enforce those promises that you made. They can make you comply in court. So sovereign immunity was an issue, gaming was an issue, fee to trust was an issue. But ultimately, here's the numbers. 2,300 acres will be retained by PG&E and will be the subject of future LCCPs, land conservation plans. So those are lands that we're going to watch for, because those could be made available later. And if they are made available later, they're going to be subject to this next process that I'm going to tell you about. About 270 acres around Lake Britain will be donated to the state parks, and that's pursuant to the settlement agreement that was entered into in PG&E's bankruptcy. Lake Britain is not too far from Burney Falls, and I don't know if any of you have ever been to Burney Falls, but it is also a state park, and I recommend you go because it's a wonderful experience. It's a beautiful place to be. And for the tribal people, it's a very sacred place. It's a massive waterfall, and the water that comes down from the waterfall, they actually spring from the ground, and it's the source of water that feeds the whole state water system. It all springs from the ground at Burney Falls, and it's a beautiful experience. It is under state park jurisdiction. And now Lake Britain will also be subject to state park jurisdiction, which today is not a terrible thing because we're developing really good relationships with state parks, and we might be able to one day have co-management or do some other things where tribal people have more of a role. But also it's a burden really to try to have authority to regulate lands like Lake Britain, because so many people come there. And so you'd have to worry about policing and what is your authority, and do you have a budget for tribal police, and it would become a very complicated jurisdictional question if the tribe had received Lake Britain, and the tribe did not petition or apply for Lake Britain. The remaining acres, 6,000 acres, are going to be retained by PG&E or donated, and that's something that, again, we're going to watch for. Again, this is all a incremental, proving that the tribal people can do it, proving that we are good stewards, and showing that we love our homeland. So again, here's the maps. The purple is still being retained by PG&E. This is the Lake Britain area. And the green was, some of it has been disposed of, some went to the tribe, and some went to some other parties. So, you know, obviously the tribe is committed to this priority of land back. It was amazing to be there when the tribe received its title to the land, and there was a wonderful ceremony up there at Hat Creek, and the land is really beautiful, and there will be a village restoration. I think there's going to be some ceremonial locations for tribal people to gather, and it's a really beautiful property. So putting that behind us now, well, while we were still ongoing in these, trying to close out these land transactions, CPUC is saying, all right, we get it. And also, frankly, Darcy Howe had now moved from the Energy Commission to the CPUC. And again, that's why it's so important that we have Native people, you know, becoming educated and taking those jobs and being a voice and having a seat at the table, because frankly, I would have never thought that I would never want to work for the state, and I wouldn't want to be doing those jobs. But thank goodness that she did, because she did, and she was a voice at the table. She was able to educate them from the inside, and the CPUC in 2018 adopted a new consultation policy. So in 2018, a lot of things were happening. We were beginning to have some changes in the administration at the governor's office. And Governor Brown had already issued a policy for consultation and started creating a position for tribal advisors in every agency. And that was really key here in California. That was a real turning point when we started having a tribal advisor in every agency. Because prior to that, when I was just in Sacramento and we had an issue with a particular agency, whether it was a tax or ICWA or you know, these utility issues, we didn't have anybody to go to. And we definitely didn't have anybody to go to that had a voice at the governor's office. So when Governor Brown created the tribal advisors, it really was a groundbreaking thing. Then Governor Newsom also issued an executive order and furthered that process of creating and establishing tribal government collaboration. The commission, they adopted their own policy, the CPUC, and they made it consistent with these governor's executive orders that it would be applicable to all California Native American tribes. And in California, that means something really specific. So there's recognized tribes, and there's a lot of unrecognized tribes in California. There's probably around 70 unrecognized tribes. And a lot of them are in areas where there's no recognized tribe. And so there's some laws have been passed where tribal California Native American tribes that are not recognized there's a requirement that they be consulted with on local and state issues today. And so these new policies also include those tribes, and it's those tribes that go through a process with the Native American Heritage Commission to be included. But the CPUC, they adopted their tribal land return policy. Initially, it was in 2018. And then I gotta say, at this point, with the CPUC, some of you might think, oh, I wanna go look at the CPUC information and find out more about this. I'm just gonna give you a big warning that the documents that they publish are really complicated looking. And that's one of my big grievances about their work in general, that their documents all look like a lawsuit. They all have captions, and they're a proceeding. If we had the same kind of rollout for a consultation policy by other agencies, a lot of tribes would probably miss it because it looks like a lawsuit, and if you're not a party, you're not going to look at it. But when the CPUC or the Energy Commission starts a new process, they call it a proceeding, and they have a rulemaking on it. Other agencies like Department of Social Services or State Parks, they just announce that they're going to have a new policy, proposed policy, and they do a request for consultation, right? And everybody can go to this consultation and they can give input. But with the utilities, it's these formal proceedings, but it's still basically the same thing. So anybody can go to these proceedings, anybody can participate in their proceedings. Tribal governments can and ideally will participate in their proceedings, because all that is consultation. Proceedings equals consultation, really, in the utility industry, at least here in California. So as I said, tribes and tribal governments includes unrecognized tribes and recognized tribes. The CPUC has a consultation policy, and this land return policy is supposed to be read consistent with the consultation policy, meaning it's open, it's ongoing, and so when they have these rulemakings and these proceedings, it's all consultation under their policy. But the new policy, it requires, so here an IOU is shorthand for an independently owned utility. So that means SDG&E down here in Southern California, PG&E, and any utility, there's been some limits on it, but it's any utility that serves more than 2,000 customers. So it could be a small utility that's serving 2,001 people or customers, or it could be a big one like PG&E. And so the new land return policy requires that all IOUs, as defined, now must give tribes in California the first right of offer. And initially, the proposed guidelines had first right of refusal, meaning tribes get a chance, and if we can negotiate, we get the first chance to negotiate. Over time, with consultations on this policy, they've determined that it should be the first right of offer, that's the appropriate legal term. And so what that means is, as it says, tribes have the first right to make an offer ahead of anybody else. And the IOUs are required to give notices to all of the California Native American tribes when they're going to propose to sell any property, and tribes have the opportunity to buy it first. And again, it says land return, but it does mean land purchase for the most part today. And again, because we're working on this in an incremental way, hopefully there's funds made available to tribes. And right now, there's actually a new program called the Nature-Based Solutions, and I didn't make a slide about it because it was just a lot of work, but through the Resources Agency in the state of California and the governor's office, they have identified, initially it was going to be $100 million for tribes, California Native American tribes, to buy land back. It's down to 70 million, but it's 70 million. And through that grant program, a tribe may apply to get money to buy land back. And I would suggest that a tribe find the land that would be made available from PG&E and write a grant to that $70 million and that fund, and use that to purchase your land back. So you're basically getting state money to purchase your land back from the utility. And whether tribes are able to thread that needle, we'll see, but that's why I wanted to talk to all of you today, because maybe somebody here has some ideas, or you have a client, or it's your tribe. And there's a lot of moving parts right now. But so first the commission, the CPUC, requires the IOUs to identify their lands, and if they're going to be made available, that they need to give the first right of offer to tribes. So this is some of the background, that there's all this history, and I shouldn't just wave my hand because this is really important, right? They're acknowledging the history, and they're acknowledging that this is the tribal land, that this is Aboriginal territory, that they took it from tribes, and that there's a process of reconciliation and healing that's underway within the state agencies. And I know when Governor Newsom issued his apology, there were some tribal people that just said, you know, that's just words. That's just words, and it's not going to mean anything until they do something. And so I would just pose that this is them starting to do something. And it really, it does put some of the burden, puts the burden on the tribes to navigate it. But it's a process that now there's $70 million for tribes to buy land back. And there's a process within the utilities that they have to sell it to you first ahead of anybody else. And this is based on the cultural and spiritual importance of our lands to all of the tribes, and that it was taken inappropriately, and that that tribes have a legal right. And I was reading through some of the comments from PG&E and the other utilities, and of course they hate this. They hate this policy. They're very upset that they have to comply with it. And maybe hate's a bad word, but I mean, strong word, but it's very clear in their comment letters that they do not want to have to comply with this. And also the Stewardship Council didn't want to have to comply with it, because the Stewardship Council, right, was still making donations. The original land return policy was adopted in 2018 as a draft. Pitt River didn't get their land back until 2022. And so the Stewardship Council didn't want to have to undo everything they did and then offer the land to tribes, because it was already in this process. And so they got an exclusion or an exemption from the land return policy. So there were a few exclusions, and I didn't get into them all here, but there's exclusions for smaller utilities, there's an exclusion for water companies. There's an exclusion for if it's just an easement. So, you know, the utilities were really concerned when there's a project and they move an easement from one place to another, that they didn't want to trigger this policy inadvertently, that the tribe could then take it. So it only applies to the grant of real property and fee title. And the goals, these are their goals. These are their CPUC's stated goals, that it's to recognize and respect tribal sovereignty, to protect tribal sacred places and cultural resources, ensure meaningful consideration of tribal interests and the return of lands within the tribe's Aboriginal territory to the appropriate tribe, and encourage and facilitate notice and participation in matters before the commission that involve land transfers subject to Section 851 through either applications or advice letter processes. And so this is where it gets complicated, right? The Section 851 and either application or advice letter processes. Unfortunately, tribes will need lawyers to be able to navigate this work. It is complicated. But once somebody is, the beauty of it is that as a lawyer, one wouldn't need to know how to do it. You can work and meet with CPC and they'll walk you through it, because that's what their consultation policy said that they would do. They said and they committed that they will work with you and they'll give you advice and they'll walk you through this process if you ask. So the commission in real life, in real time, the commission gets a request from an IOU that they have some surplus property. I've seen this happen quite a bit with some of my clients where they get notices now from PG&E about these surplus properties, and a lot of them are dealing with buildings. And many of the buildings are in cities. So they're not necessarily rural land near the waterways like we've been talking about. But those are properties that tribes can reacquire too. And I know for my tribe, having if a shortage of office space, if there was PG&E facilities available for sale, we would really be interested, especially if we could use some of the other state grant funds for it. Just before I forget too, the Nature-Based Solutions Grant Program, there's a consultation going on with that one. I've been telling all of the agencies we're in a consultation fatigue area at this point in time because there's so many agencies doing so many things, because we're doing CPUC, CEC, state parks, resources agency, and then we have broadband and middle mile, and there's other things that are going on like other presenters are going to talk about later today. And it's just a lot of time, and it's a lot of time and resources for tribes to be putting into these consultations. But at the end of the day, the main thing is that you're aware of them, that they might sound like it's something different than it is. Because a lot of these programs that they're consulting with tribes on today is actually just money. It's grant programs, and it's access to things. So I want to encourage everybody to participate in those. And it is a lot of work, because I've been trying in my office to keep track of all of these initiatives, and it's a lot of work keeping up with it. But I think that as tribes work their way through it, they'll be able to find some, hopefully some access to things. And then the other part of it is contracting, because the contracting has been a problem with this state because, well, for a number of reasons. But one of the big reasons in the contracts, whether it's because of the fires that happen, and then there's monitoring required, and a lot of tribes have dealt with fires, and then the subsequent tribal monitoring and the impacts to burials and cultural sites. And when we're doing contracting for that work, there's always a waiver of sovereign immunity. And when there's contracting for this new housing money, there's waivers of sovereign immunity. And if you have a project that has a contract with a state agency that has a waiver of tribal sovereign immunity, I would first, before turning away the money or before not applying, I would actually recommend that you work with them, because they are coming around to find ways around the sovereign immunity waivers if it's a problem for your tribe. I have a project right now with a housing and community development agency, and they have a waiver requirement for it's, I think, $1 million housing grant, and they're working with us on the waiver and figuring out ways to maybe we just have a bond or some other workaround where we don't need to have a waiver. And if it is just purely a grant where the tribe's going to get this money and buy land, it could be a reimbursement where the tribe has to pay the land first and then get reimbursed, and then you don't have a waiver. So there's lots of ways these are going to work together, these programs. But ultimately, it's to, as this bottom point says, provide opportunities to return lands to California tribes that are within their territories. Again, this slide is really dealing with the access to information. And like I said, just generally a few minutes ago, the CPUC is taking the responsibility of working with you so that you have access to whatever information you need. So if you don't know what to do, they recommend you just contact their tribal advisor, and they will walk you through what it is that you need and what it is that you must know and what your deadlines are, and they will walk through all of the information. But the IOUs are now required to notify tribes of all of these opportunities whenever it comes up, subject to those limitations that I said, that it's over 2,000 customers, and that it's triggered by this Section 851. And Section 851 is a particular rule with a CPUC when they sell land. And there's just some rules that get triggered when they do that. And if they fail to provide notice to the tribes, then the commission the commission ultimately has to approve when the IOUs sell land. And so if, say, PG&E didn't inform the Pit River tribe with enough time, and they tried to act like they did, and I wouldn't be surprised if that happened. And then the tribe, before the land gets sold, the tribe says, wait a minute, we want to have our first right of offer, and the proceeding with CPUC isn't done yet, they'll hold it up. And that is really unique, right? Because in the past, it's just like, you're too late. You're out of luck, you're too late, you missed the opportunity. But they are giving tribes a lot of leeway when we're late to the table. And the reason they're doing that is because they understand how hard this is, and this is their new policy. They've committed to doing this and working with tribes to the highest extent possible. So they want to facilitate the information. It's pretty daunting language, and I don't know, the utilities it'll take them some time for them to get comfortable with the fact that the tribes are really the sleeping giant that has now been awakened, and we have the right to step in and interrupt their business. Law judges, their ALJs, have to ensure that the tribes have received the information and that they're not interested in making an offer. And if the IOU, so the IOU has to submit an application to dispose of the property, and this includes PG&E's retained lands. So those lands that I mentioned, I showed the pictures where it's all purple. If you have a question in your mind that maybe your tribe or a client of yours might have lands within PG&E or SDG&E's areas for disposal, or within the Stewardship Council areas, there's websites and you can look them up, and they do show which areas they are, and there's a little bit of a rabbit hole that you have to go down. But the retained lands, when those become available, tribes can definitely step up, and they have to show that there was a consultation with the NHC and that the notices went out. The commission will grant the tribe a first right of refusal for any IOU request to transfer non-FERC jurisdictional property. So non-FERC, that's going to be everything but what was in the purple. It doesn't say that they won't approve a transfer of FERC jurisdiction. It just says we don't have a first right of offer. And then there is a rebuttable presumption. And in the law, a rebuttable presumption is really important, because what it does is it puts the finger on the scale a little bit for tribal governments. It's a rebuttal. It means the utility has to show that it's not in the public interest to give you this land back, and to have the first right of refusal. And that's going to be really difficult for them to do. I could think of a few examples where they could say, well, it's not really in the public interest, that this building be in tribal hands. But given the fact that the CPUC has built this foundation of rule and policy that tribes were the first people here, tribes had the land stolen, and so on, that the presumption is really hard to beat. So the retained lands are subject to it, and also if it's going to go to somebody else, there has to be mitigation measures for the cultural resources that are there before the sale. And that's really important also, because if the tribe doesn't want the burden of managing the lands, they can intervene in the proceeding where the sale is going to take place, and they can have written mitigation measures on the sale. And so they are going to run with the land. And when you're protecting cultural resources, that's actually the best measure that you could have, because it doesn't fade over time. It's going to be an encumbrance on title that they have to have to follow these mitigation measures. There's a tribal liaison. I think it's still Stephanie Green, although I feel like it might be somebody else now. But on their website, they have a tribal liaison, and the tribal liaison is going to be the person that anybody can contact to see if they're interested in something and ask questions. Stephanie Green has always been great. She has a lot of experience on the other side of CPUC work. So on one hand, we're doing all this land return, land protection, but then there's also where tribes are developers, right? We see a lot of the vendors here today that are there about utilities and preservation and conservation easements and things like that, or microgrids. So Stephanie Green would be a contact, or they have their just public advisor email, and anyone can email or call, and it'll trigger a chain of communications. And so I feel like I've talked to you at you enough, and I am wondering if anyone has any questions at this point in time, and we could have a conversation.
Bonjour, I'm Aurora Conley from Bad River, Lake Superior, Wisconsin. I just wanted to know if there was more background information about like the beginning of PG&E and how they had illegally acquired those lands, and where we could find some more of that. And then just more of your contact information for network and whatnot too, especially in terms of like the microgrid and where we're developing with renewable energy and trying to like restore and get some of our land back, and then what we're actually going to do with it in terms of development or what that might look like. Thanks.
Yeah, well, I'm happy to share this presentation with anybody. I do think that this land back effort and PG&E's theft of the land, I say that as a Native person. Of course, they don't see it that way. They think they got it, they bought it, or they got it through the state, right? Because the state is really the one that took it from the tribes here. But yeah, from another jurisdiction, you may have a similar history, right? Where the Native people were, the lands were taken by the state and through state actions, and then later private enterprises have those lands and those resources, and they're developing utilities but not serving your community. And that's something I think more needs to be written about that, but as far as it being available, I'm happy to talk to you about it. It is something that I think it would be helpful to have more literature about how we tie that history to current policy and take it into a microgrid kind of situation or energy resilience. And that's one of the conversation also that's going on here. The utilities are also being required to develop, they call them, there's a lot of acronyms in the energy and utility world, and it's called a CAVA, and it's a Community Action Resiliency, it's about energy resiliency and climate change, that's what it is. And because of climate change, we have a situation where the utilities want to go green, right? They want to go green, and a lot of these resources, like hydro is considered green, right? It's not natural gas. It's not. They say it's not extractive, but it is. It affects the fisheries and it affects the water. And there's been a lot of litigation over the years about the fish and about the species that are harmed by dams. And when the dams are no longer viable because there's lawsuits and they're supposed to put fish ladders in the dams, then it becomes impossible to run the hydro facility anymore because it costs too much to do the upgrades. And so some of these hydro facilities, they can't even sell them anymore because they're not worth anything. You have dams on rivers that are not up to legal standards, and they want to sell them, but there's not enough buyers out there. But all of those agencies have to do these climate adaptation plans here in California, and as a part of that, they're looking at green energy and how green energy can serve tribal communities. And that requires a complete reworking of the grid in California. It just does, and that's a whole other presentation, but the grids, I think, across the country are all outdated. They're all built for a certain kind of power, and in order to upgrade these grids so that there can be community-based energy solutions in these grids, there has to be tribes at the table, because tribal people are all across the state, right? And we've been here forever, and we know we're not going anywhere. And so we're unique partners in the dialogue about what to do next with climate change and adapting to it. And quite frankly, because tribes, we've adapted. And I was in a consultation the other day with I think it was the Energy Commission about climate adaptations. And we've already, as Native people, we've already went through an apocalypse. You know, we've already had to adapt to, you know, loss of our lives through disease and genocide and land loss and cultural assimilation. We know how to adapt. We've had to adapt, and tribal people are very resilient in that way. And because we're resilient, you know, I think we're a resource for these agencies to be talking to us about how to make it better and how we can participate in that. So yeah, these topics are all connected in a broad way. And so that's a good question, because I was hoping that this would sort of generate those thoughts for people, that here's what 20 years of work can do. And what I told the utilities the other day was that there's no reason why there can't be a lot of communication for the next 20 years. And 20 years isn't really that long, but if they really dug in and worked with Native people, a lot can happen in 20 years. So yeah, this is related to climate resiliency. It's related to how tribes can become utilities. They can own their own utilities. We could take over some of these facilities and maybe get federal funding to upgrade them and have that be an enterprise that each tribe has for either its own production or to, you know, put on the market. So all of these things are really connected, for sure. I hope I answered your question. I'll give you my card later. I'll share information with you.
Good afternoon. Linnea Jackson, Hoopa Valley Tribes Public Utilities.
Oh, hi.
Is it on?
Yeah, she was on the conversation the other day.
Right.
Yeah.
Right. So we've crossed paths now.
Yes.
It's meant to be. Okay. I wanted to talk about the tribal land back policy, because Hoopa Valley Tribe provided comment on that. And there's going to be issues when there's multiple tribes in the Aboriginal territories, and they need to find out how they're going to do dispute resolution for things like that. Mm-hmm. I think tribes should be able to know the potential properties within their jurisdiction, because you're going to have to come up with financing and funding. Tribes just don't have like a lot of cash on hand to be able to make that financial transaction within whatever time frame is going to be allotted. I asked questions about appraisal valuation, and you mentioned about PG&E not necessarily always managing the land in a mindful and professional manner. So I think there needs to be considerations for that. Who pays for that appraisal? And then you mentioned a written notice, and is that one letter that goes to the tribal chairman when really, you know, he has so much under his thing that it could get lost in the shuffle. I mean, Hoopa Valley Tribe has 60 departments, and that probably should come to maybe the planning director and myself. And I think they really need to think about how that written notice and that consultation to tribes is provided.
Yeah, so. Thank you for all of that. That's really, you're right on. The multiple tribes all going for the same site it's potentially a problem. You know, it definitely is potentially a problem, and that's always the toughest one when we have any kind of return of anything, whether it's NAGPRA, CalNAGPRA, you know, where there's a return of remains and different tribes can claim it. It's a challenging issue. They did talk about it I tried to comb through all of the documents before I came here. I tried to comb through the guidelines, because they have guidelines too, so there's a lot of layers. But there were comments from tribes about the multi-tribe concern. And they are trying to work that out with the Native American Heritage Commission, where the NAHC would help with dispute resolution. And so that's the solution on the table right now that will be available if there is a tribal dispute over a land return or multiple claims. So they're going to try to negotiate those through the NHC, and if that's something that the Hoopa Valley tribe doesn't like, or sees another viable solution, then I would just suggest either writing a letter or reaching out to the tribal advisor and giving your feedback to them, because they are supposed to be taking note of, and I do think that they appreciate it, because sometimes they feel, I think that they've told me that they don't hear, so they're having to make it up as they go along, and so they're doing their best. And because I've submitted comment letters for different clients along the way, and in their proceedings, they actually summarize every tribe's comment. I know the Yurok tribe was on there. I don't remember seeing Hoopa, but I might have just missed it. But the Yurok tribe had a lot of comprehensive comments that were so detailed that I couldn't even follow them, because you would have to have the policy right there and really look at it. But they do seem to be very responsive when you have line edit comments, and then later they say, we did make a change. So they are actually adapting to the comments. And the appraisal, they don't really talk about an appraisal in the land return policy, but it's based on fair market value. With that said, the CPUC is trying to navigate those prices so that they are reasonable. And that was one of the comments actually by a unrecognized tribe in Southern California. I think it was in around Los Angeles. They were saying that they didn't have funds, and that tribes should be able to do $1 transaction. That they literally is land return. And maybe that's our goal. This is where it's starting, and as tribes have experiences where it doesn't work and the CPUC sees that it doesn't work the way it's written, then we'll have to figure out how it can be more of a reparation, because that's ultimately what it should be.
And then my last comment was on tribes needing that technical expertise and the legal expertise. So even Hoopa Valley tribe being a large tribe, we have one tribal attorney on staff.
Yeah.
And so it's not feasible for us to, make sure that we're always providing public comment and being a party to issues, because we just don't have that capacity. So I think about some other smaller tribes where the resources might even be less, and I think there should be legal assistance available to tribes to help us navigate that as well.
I agree, and that was some of the comments that they have received. They've received that kind of feedback, and I do recall something where they will do that. They will give technical expertise, and that's kind of the next program is technical expertise. The tricky part is ethical, restrictions, because I, as an attorney, I have to have an attorney-client relationship with my clients and have a contract and all of that. So they're trying to figure out how to take that next step. But I think it would be great if you would just call the tribal advisor and talk to them, because that way, and that's what I said. I was at a meeting earlier this week or last week, and they said, I was telling them that we shouldn't have to read everything, understand it, figure out what we don't like about it, and then write a letter, and then get it through the tribal council, and maybe by that time the deadline's passed. And we really should be able to provide comments just on a one-on-one basis, and because it's not fair, because tribes don't have the expertise, and they can't all pay for a lawyer to spend hours, looking at everything and coming up with a recommendation for that tribe. Because what one tribe says might not fit you, so you can't rely on other tribes to speak for you, obviously. So they are looking at that issue, but that was why I wanted to talk about this here today, was because I feel like I'm in a position where I'm understanding it, and I've seen it, and I've worked on it, so I wanted to share it with all of you so that you could at least get kind of the general, gist of everything, and then see what applies to you and where to look. But the Hoopa Valley Tribe definitely is in a unique situation because of the utilities in your area. And I do think it's something of importance. So the Nature-Based Solutions Grant is that $70 million. It is really tied to the 30 by 30 program for the state. So it's the 30 million acres in 30 years, or 30%. I always mix up what the 30 by 30 is, but it's 30% of the open space for conservation. And so if the Hoopa Valley Tribe had identified lands that they wanted to keep in, you're not developing it. You're not going to build a casino on it or build a coal factory or, some kind of extractive thing there, then it could fit in the 30 by 30 funding. And that's why they're trying to piece these separate programs together so that you would have the money and you would have the technical expertise and you would be able to identify those lands. But yes, it's a lot of work. It is absolutely a lot of work. So I'm happy you're here.
Gabrielle Tateushkashka. I'm from the Lake Traverse Reservation. And I just wanted to comment that when it becomes problematic when a foreign culture tries to dictate to tribes about shared territories, and that as human beings we all understand we share the sun, we share the rain, we share the wind, but for this foreign culture, American society, they can't understand the concept of shared territory. And I think that's got to change, because it will always be problematic for communities where there's shared territories.
Yeah, that's right. There are shared territories. The difficulty with these transactions is when you have two tribes both wanting to have the first right of offer on the same parcel, and then those tribes who do they pick? And that's where the controversy comes up, and that's where the Native American Heritage Commission is really here in California, is the only state agency that does dispute resolution between tribes, and they have a history of doing that because of burial site protection. And we have that come up all the time, right, with burial sites, because different tribes can consider that their Aboriginal territory and their ancestor. And really what the NHC does is tries to have the tribes make a decision together. And that's our best outcome. You're 100% right. We don't want the state ever telling us whose territory it is. And so far, the state of California has been pretty good at navigating that. But the disputes happen. And what my larger concern would be if the utilities use that concern as a reason to get out of transferring it to any of the tribes. So we do have to figure out a way to navigate it when you have two tribes both wanting to have the first right of offer on one piece of land, and figure out how that will work. But the other thing that you mentioned was notice, that will the notice be good enough? And that's a really important comment to give to the CPUC, because there's so many notices and there's so many programs. You have to actually chase them down to keep up with them. So it's difficult if you're a chair and you're getting all those letters. It's impossible to keep up with them. And I think they're understanding that at these agencies, that we are in consultation fatigue right now. But they're going to have to give us time to be able to respond, and that's going to be a challenge. Okay. Well, thank you for your attention. I really appreciated the time, and have a good rest of your conference.